27. Discussing problem questions. Dear Alex, a problem question presents you with a set of facts and asks you to discuss what legal conclusions we might be able to draw from those facts. What sort of legal conclusions we are seeking to reach in doing a problem question will depend on what kind of subject the question relates to. When you are doing a criminal problem question, you will usually be expected to look at a set of facts to determine who, if anyone, has committed a crime on those facts. When you are doing a tort problem question, you are usually looking to see what remedies, if any, are available to someone who has suffered some kind of harm. There are a number of different issues that you might be expected to address in doing a contract problem question. It could be asking you whether a particular promise is legally binding, or whether someone can get out of a deal that has now proved to be a bad deal for them, or what remedies are available to someone who wants to hold someone to a deal, or what the parties to a deal are required to do for each other, given the nature of that deal and its terms, and so on across the range of different subjects you will study at university. In what follows, I will give you some general guidance on how to do problem questions. I must emphasize that the general guidance below does not apply in the case where you are doing a tort or criminal problem question. There are specific methods for doing tort or criminal problem questions, and I'll explain those later on in this letter. But I'll start by setting out a general approach to doing legal problem questions. General guidance. The most basic word of advice I can give you on doing problem questions that are not tort or criminal problem questions is: identify the issue or issues that the examiner wanted you to discuss in answering the question. Issue spotting is a crucial talent that you need to develop if you are going to do problem questions well. Here are a couple of different approaches to issue spotting that you might want to adopt in doing a problem question. I emphasize again that what I am about to say does not apply to tort or criminal problem questions. Nothing I say in this section is of any relevance to doing those kinds of questions. 1. Get inside the head of the examiner. One way of issue spotting is to ask yourself, why did the examiner think this was a good problem question to set? What sort of difficulties did the examiner think that this problem question gave rise to? For example, consider the following mini problem. Henry was infatuated with Jenny and would do whatever she told him to do. She used her influence to get him to make a loan to her friend Clara, who was setting up a hairdressing business. Clara's business is now in severe financial trouble. Advise Henry. Why did the examiner think this was an interesting question to set? He or she could hardly think that there was an issue here over whether Henry could get out of, or in lawyers' language, rescind the contract of loan between him and Clara, as it's fairly obvious that he could, provided Clara knew, or ought to have known, that Henry was only lending her the money because Jenny wanted him to, which she almost certainly did. No, there must be something more here that the examiner wanted you to address. And in fact there is. Can Henry sue Jenny for compensation for the loss that he is likely to suffer as a result of lending money to Clara? That's the issue you would need to focus on if you were doing the above question. In trying to get inside the head of the examiner, in order to see why he or she thought their problem question was a problem, it is useful to approach the question on the basis that every word counts. Ask yourself, why did the examiner write the problem question in the way he or she did? For example, in the above question, why didn't the examiner make it that Henry was infatuated with Clara and Clara used her influence over him to get him to lend her money for her business? Why is Jenny in this problem question? In thinking about that, you would quickly come to the conclusion that Jenny is actually crucial to the resolution of the issue that the examiner wants you to address in doing this question. However, I should enter 2 words of caution here. The first is that not every word actually counts. For example, the fact that Clara was setting up a hairdressing business, as opposed to some other kind of business, is not really relevant, it's just there for color. So you should only presume that every word counts. The second point is that examiners sometimes plant red herrings in their problem questions, words that are designed to mislead the less able students into thinking that the problem question raises a particular issue, when in fact it doesn't. I strongly disapprove of this practice, but it does happen. So you have to be tough-minded in spotting issues in a problem question. If you think a particular feature of the problem question is irrelevant to its outcome, then stick by your judgment and don't second-guess yourself. Though you may want to explain why that feature of the problem question is irrelevant, I address this point later on in this letter. 2. What do the parties want? Another way of spotting the issues raised by a problem question is to ask, what do the parties want? This will usually give you a good clue as to what sort of issues the problem question has been set up to raise. For example, in the mini problem set out above, if Henry wants anything, he wants to get his money back. Henry won't be able to get his money back from Clara because she's evidently got no money. If he wants to get his money back, he has to go against Jenny and find some way of arguing that she should compensate him for the loss he has suffered on his deal with Clara. So focusing on what Henry wants allows us to spot the issue that the examiner really wanted us to address in doing this problem question. Once you have identified the issues raised by the problem question, and it would be a good idea to start your answer by saying something like, this question raises 3 issues. 1, 2, 3. To make it clear what those issues are, then you need to discuss what the law says about those issues. Some academics advocate that you do this by identifying the rule that governs that issue, and then apply the rule to that issue, and in light of that reach a conclusion as to what the law says on that issue. This is the so-called Iraq method of answering problem questions. Spot the issue, state the rule governing the issue, apply the rule, and reach a conclusion. I'm not much of a fan of Iraq because 1. It is not often clear whether there is a rule that governs the particular issue you want to resolve. And 2. There may be more than one rule that is relevant to the resolution of a particular issue. For example, the real difficulty that the problem question about Henry gives rise to is whether there exists any rule that would allow Henry to sue Jenny for compensation for inducing him to make a bad loan to Clara. There is a rule that wrongdoers should compensate the victims of their wrongs. But even if that rule doesn't apply here, it may still be the case that there is another rule that will help Henry out. My preferred approach to discussing the issues raised by a problem question is to focus on the possible legal arguments that are relevant to those issues, and work through those arguments explaining whether they are valid or invalid. For example, in the problem question involving Henry, having first identified the issue you are going to discuss as being whether Henry can sue Jenny for compensation for inducing him to make a bad loan to Clara, you should then go on to say that there are 2 possible bases for Henry's claim. 1. That Jenny committed a legal wrong in using her influence over Henry to get him to lend money to Clara. And 2. That even if Jenny's use of her influence didn't amount to a legal wrong, she is still liable to compensate Henry for any losses suffered by him as a result of getting him to act in a particular way. And you would then discuss whether either of these arguments is valid or not. So the first argument turns on whether there is any legal support for the idea that someone who possesses influence over someone else has legal duties not to exercise that influence to the detriment of the person being influenced. The second argument turns on whether there is any legal support for the idea that if it induces B to act in a particular way, and B suffers loss as a result, A can still be held liable for that loss, even if it didn't do anything wrong to B in inducing B to act in the way B did. Answering the problem question properly will require you to address both of these points through detailed discussion of the law as it stands at the moment. So that's the general approach that I think you should adopt to doing legal problem questions. There are a few more general tips that I want to give you on answering problem questions. But first, I'll keep my promise to set out the specific approaches you should adopt in doing a tort problem question and a criminal problem question. Doing tort problem questions. The basic approach that you should adopt in doing a tort problem question is this. 1. Identify a claimant, someone who wants to sue someone else for compensation. 2. Identify a defendant whom that claimant might be interested in suing. 3. Identify a cause of action, tort, or rule of liability under which the claimant might try to bring a claim against the defendant. 4. Consider whether, given what has to be established for the claimant to bring a claim under that cause of action, The claimant has a good claim against the defendant. 5. If the claimant does not have a good claim under that cause of action, go to step 6. If the claimant does have a good claim under that cause of action, go to step 7. 6. Go back to step 3 and identify another possible cause of action that the claimant might have against the defendant. If you have exhausted all possible and plausible causes of action that the claimant might have against the defendant, then go to step 7. 7. Go back to step 2 and identify another possible defendant whom the claimant might be interested in suing, and repeat steps 3, 4, and 5 in relation to that defendant. If you have exhausted all possible and plausible defendants that the claimant might want to bring a claim against, then go to step 8. 8. Go back to step 1 and identify another possible claimant, and repeat steps 2, 3, 4, and 5 in relation to that claimant. If you exhausted all possible and plausible claimants that might want to bring a claim in the problem question you are considering, then stop writing. This is all a bit abstract, so let's apply this approach to a particular problem question. Jeffrey, a world-famous violinist, decided to put on a concert to raise funds for his local school, Sunshine College. He hired out a hall owned by the local council for the night of the concert. Admission was free, but notices outside the hall informed concertgoers that they would be invited to make a financial contribution to Sunshine College at the end of the concert. Concertgoers were also warned that no responsibility is accepted for the safety of concertgoers' person or property while they attend the concert. It turned out that far more people wanted to attend the concert than there were seats in the hall, and many people had to stand crowded together at the back of the hall while Jeffrey performed. Matilda, an 80-year-old, turned up late, and as no one offered her a seat, she had to stand at the back of the hall. She soon fainted due to the heat and cramped conditions and twisted her ankle in the fall. Donald, a music lover who came to the concert, but never intended to donate anything to Sunshine College's funds at the end of the concert, wandered round the hall in an attempt to find a seat, and in doing so slipped on a patch of oily water, which was in one corner of the hall. He grazed his knee as a result. Jeffrey had arranged with the council that their cleaning contractors Easy Clean would clean the hall before the performance, but no one in the council had bothered to tell Easy Clean, and Jeffrey had been too busy on the day of the concert to notice that the hall had not been cleaned. The concert was a resounding success, and £8,000 was collected at the end of the concert. The money was collected by Wendy, a friend of Jeffrey's. Wendy then promptly disappeared with the money. If you follow the approach to doing tort problem questions set out above, your problem answer will be structured as follows, with the following headings: Matilda's claim for compensation for fainting and twisting her ankle. Claim against Jeffrey 1A in negligence. 1B under the law on occupiers' liability. Claim against Sunshine College under the law on occupiers' liability. Donald's claim for compensation for grazing his knee. Claim against Jeffrey 1A in negligence. 1B under the law on occupiers' liability. Claim against Sunshine College under the law on occupiers' liability. Claim against Easy Clean in negligence. Sunshine College's claim for compensation for loss of the £8,000. Claim against Wendy in conversion. Claim against Jeffrey in negligence. There are 3 points I want to make in particular about this method of doing tort problem questions. 1. No issue spotting. Under this approach, you don't need to do any issue spotting. All you have to do is identify a claimant, someone they may want to sue, and this is the crucial bit of tort or rule of liability under which they might bring their claim. Then all you have to do is apply the law on when one person can bring a claim for that tort or under that rule of liability to the situation you are considering. It is the law which will tell you what the issues are that you need to be considering. You don't have to spot them yourself. So when you are doing a tort problem question, let the law guide you as to what you should be discussing. Don't try to decide for yourself what you need to be talking about. Just let the law take you home. 2. But lots of issue weighing. Having said that, you need to decide how much time you are going to spend on each of the issues raised by the problem question. The key here is to dispose quickly of the issues that can be straightforwardly resolved, and invest most of your time on the tricky issues that require a lot of discussion of the relevant authorities and academic opinion. 5 minutes spent writing about one such tricky issue will get you far more credit with the examiner than 5 minutes making a point about the law that is so obvious it could be made in 1 or 2 lines. 3. The need for rigor. This takes me on to the third point, which is the absolute need to be completely rigorous in doing tort problem questions. If you are not going to miss any issues, you have to consistently follow the step-by-step approach to doing tort problem questions set out above. And you have to apply the law rigorously in determining whether a particular claimant can bring a claim against a particular defendant. This is the primary reason why students find tort problem questions much more difficult than any other problem questions, even though the fact that they don't have to spot any issues should make tort problem questions much easier than other problem questions. Students find it very, very hard to be rigorous in answering tort problem questions. But you have to learn. A lack of rigor in doing a tort problem question is always fatal, without exception. Doing criminal problem questions. The basic approach that you should adopt in doing a criminal problem question is this. 1. Identify a defendant who might be charged with having committed a criminal offense. 2. Identify an offense that he might have committed. 3. Consider whether he has committed the actus reus of that offense. If he has, or arguably has, go to step 4. If he has not, go to step 6. 4. Consider whether he has the mens rea of that offense. If he has, or arguably has, go to step 5. If he has not, go to step 6. 5. Consider whether he has a defense to being found guilty of committing that offense. If he does, then go to step 6. If he does not, then conclude that he will probably be found guilty of committing that offense, and go to step 7. 6. Conclude that the defendant will probably not be found guilty of the offense you are considering, and go to step 7. 7. Go back to step 2 and identify another offense that defendant might have committed and repeat steps 3, 4, and 5 in relation to that offense. If you have exhausted all possible and plausible offenses that defendant might have committed, then go back to step 1 and identify a different defendant who might be charged with having committed a criminal offense, and repeat steps 2, 3, 4, and 5 in relation to that defendant. If you have exhausted all possible and plausible defendants, then stop writing. Again, this is a bit abstract, so let's apply this approach to a concrete criminal problem question. Albert was HIV+. No one other than Albert and his doctor was aware of that fact. Albert had always fancied Brittany, who was engaged to Charlie. One night Albert and Brittany were at a party together, and Albert spiked Brittany's orange juice with very strong alcohol. Brittany got very drunk and told Albert that she was scared that Charlie had been unfaithful to her. Albert lied to Brittany, telling that he had found out that Charlie had slept with Brittany's best friend, Deborah, a week ago. Albert suggested that Brittany get her revenge by having sex with him. Brittany said, "Okay, but only if you use protection and pay me £300 cash in advance." Albert didn't have the money, but approached his very rich friend Ernest, who was also at the party, and told him, "Look, I'm in a tight spot. I sold some cocaine to a friend of mine, and he was caught by the police, and he's threatening to tell them I was his supplier unless I pay him £500 tonight." This was untrue. Ernest, who has often bought drugs from Albert, went to a cash point and withdrew the £500 needed, which he then gave to Albert back at the party. In the meantime, Albert bought a pack of condoms from a machine, using counterfeit coins to buy them. Albert then gave Brittany £300, telling her, "Don't tell Ernest I gave you this. I borrowed some money off him recently by telling him I was strapped for cash, and he wouldn't like it too much if he heard I'd been flashing this much money around." Brittany then had sex with Albert. Unfortunately, the condom they used was defective and Brittany is now HIV+. If you follow the above approach to doing criminal problem questions, then your answer to this question will be structured as follows, with the following headings. Albert. Maliciously administering noxious substance with intent to injure, aggrieve, or annoy. Fraud by lying to Brittany. Fraud by lying to Ernest. Theft of £500 given him by Ernest. Fraud by using counterfeit coins. Rape. Causing a person to engage in sexual activity without consent. Malicious infliction of grievous bodily harm. Brittany. Handling stolen goods. There are 3 points I want to make about this method of doing criminal problem questions. 1. No issue spotting. Again, if you follow this method of doing criminal problem questions, you won't need to spot any issues. Rigorously asking whether the defendant had the actus reus and mens rea of the offense you are considering, and whether the defendant had a defense will highlight for you all the issues that the examiner meant you to consider in setting the problem question. But you will again have to decide how much time you will spend on each issue, spending more time on the tricky issues than the obvious ones. And 2. The need for rigor. You have to be rigorous. You can't afford to get the law wrong in stating what the actus reus or mens rea of a particular offense is, and you can't afford to jump around and consider whether the defendant has the mens rea for a particular offense before you consider whether he or she has committed the actus reus. Once again, a lack of rigor will inevitably prove fatal. 3. Limitations. While the basic approach to doing criminal problem questions in this way is sound, it should be noted that there are times when you have to make a slight adjustment in applying it. First, there are some offenses that you can't divide neatly into having an actus reus and a mens rea gross negligence manslaughter committed when one breaches a duty of care. 2A's breach causes B's death. 3A's breach is so serious as to be worthy of punishment, and constructive manslaughter committed when it commits an unlawful and dangerous act which causes B's death are 2 good examples. But in those cases, you simply apply the definition of the offense. Secondly, when you are considering whether a defendant has committed an offense as an accomplice, you can't ask whether the defendant has committed the actus reus and mens rea of that offense, but must instead apply the rules on when someone can be held to have committed an offense that someone else committed on the basis that he was an accessory to that offense. But if you are going to consider whether a defendant is guilty of an offense as an accomplice, make sure you first consider whether some other defendant is guilty of that offense as a principal offender. Further words of advice. Now that I've laid down the basic guidelines for doing all problem questions, here are some further tips for doing any problem question. 1. Uncertainty in the law. Don't be afraid of admitting that the law on a particular issue is uncertain. Sometimes a problem question will be set precisely because it raises issues on which the law is uncertain. As I said in my letter to you on some traps to avoid, uncertainty in the law is due to vagueness, gaps, or contradictions in the authorities. So long as you can argue convincingly that the law on the issue you have to consider is uncertain because of one of those 3 factors, then you shouldn't be at all afraid to say that it's difficult to know how the problem question would be resolved. Having said that, you shouldn't rest content with simply saying that the law as it applies to your problem question is uncertain, because it might say X or it might say Y. You should then go on to explain what the answer would be to your question if the law said X, and what the answer would be if the law said Y. And Roman 2, whether you think the law should say X or should say Y, and why. 2. Uncertainty in the facts. A is thinking of buying a particular car. B tells A that if A buys the car, B will service the car for free every year. A buys the car. Whether B is bound by his promise to service A's car will depend crucially on whether B was making his promise with the object of inducing A to buy the car. So if B was selling the car, then B would be bound. But if A and B were friends, and B made the promise over a drink in the pub, and B was relatively indifferent as to whether A bought the car or not, then B would not be bound by his promise. The examiner hasn't supplied you with that information, so you have to say, we need more information as to the circumstances under which B made his promise before we can determine whether B is bound by his promise. But don't just say that. Explain what information is required and what the legal position would be in the various different scenarios in which B might have made his promise. 3. The importance of being straightforward in answering a problem question. Just focus on the facts that have been set, and don't make any unlikely suppositions as to what might have been going through the actors' heads when they acted as they did. For example, in the criminal problem question above involving Albert, the examiner has not said that Albert was aware that the condom he used in having sex with Brittany was defective, so answer the question on the basis that he wasn't aware. It's highly unlikely that the examiner deliberately meant to leave that issue open for you to discuss what the position would be I if Albert was aware, and Roman 2 if Albert was unaware. So why make more work for yourself and overcomplicate, and possibly screw up your answer by considering possibility I? One way of helping you decide whether or not you were meant to consider a particular possibility is to ask yourself, if I don't consider this possibility, will the examiner think, I can't believe they didn't consider that issue? If the answer is no, then don't consider it. Remember that problem questions are, by and large, set so that the best answers to those questions will be easy to identify. So the best answer is unlikely to rest on some very subtle and obscure interpretation of the facts. 4. Negative outcomes. It can be just as important, in answering a problem question, to show that you are aware that applying the law to a particular question will result in a negative outcome, as it is to show when you are aware that applying the law to a particular question will result in a positive outcome. What I mean by that is that sometimes a question will be set in order to test you on whether you can see that a particular claim can't be brought in that situation, or whether you can see that a particular defendant isn't guilty of a particular offense. For example, when Brittany has sex with Albert without knowing of his HIV+ status, the examiner might have been expecting you to consider, however briefly, whether or not Albert committed the crime of rape in having sex with Brittany. The fact that the cases are clear that Albert did not commit rape in this situation is irrelevant. The examiner wants to know whether you know that. On the other side of the divide, my plan for answering the tort problem question on Jeffrey's violin concert doesn't consider whether anyone might be able to sue Sunshine College on the basis that they are vicariously liable for any torts committed by Jeffrey. This is because it seems so obvious that Jeffrey isn't an employee of Sunshine College that it's highly unlikely the examiner who set this problem intended someone answering this question to make that point. When it comes to negative outcomes, it can be difficult to judge whether the examiner wanted you to show that you were aware that the law did not make anyone liable in a particular situation. If in doubt, err on the side of caution and mention the fact that a particular actor is not liable. You can only get marked on what you write on the page, and you won't get credit for points that you saw but thought were too obvious to mention. 5. Obvious points. But where a point is obvious, don't dwell on it. It is tempting, when you see a point that you are sure of, to make the absolute most of it before going on to more uncertain terrain. But once a point is made and established, you won't get any credit for writing any more about it. 6. Headings. It is so important, in writing a problem answer, that you use headings to organize your answer. This helps you keep track of what issues and points you have considered so far, and more importantly, what you still have to consider. And it helps the examiner see what issues and points you have dealt with, and encourages him or her to give you proper credit for dealing with them. Do everything you can to show off how good your answer is. Don't make the examiner do any work to see that you have provided a proper, comprehensive answer to the question set. 7. Statutes. You will almost certainly be allowed to take a statute book into the exam with you. Given this, do not, I repeat, do not copy out any provision from the statute book in doing a problem answer. You won't get any credit for doing so, and you will waste valuable time. Simply get on with applying the provision in the statute book to the situation you are presented with, and in your answer refer just to numbered sections or subsections from the statute book to make it clear which bit of a statute you are referring to or applying. For example, here's a bit of a model answer I wrote for my students to a problem question, which raised the issue, among other things, as to whether a could sue B, the owner of a dog Rex, which had a tendency to attack people wearing red, under the Animals Act 1971. In order to sue B, As the keeper of Rex because owner S. 63A has to show because Rex does not belong to a dangerous species that his bite marks were a result of Rex having a characteristic that one meant that he was likely to cause the kind of harm that is suffered, or that if he caused that kind of harm, it was likely to be severe. S. 22A. 2 was not normally found in dogs, or only normally found at certain times, or in certain circumstances. S. 22B. 3 was known to be. There seems no problem arguing that all these conditions are satisfied. Rex's tendency to attack people wearing red meant that he was likely to cause the kind of harm that is suffered. It was an unusual characteristic for dogs to have, and it was known to be. 8. Cases. There's an old story about either the Oxford or Cambridge law faculty. I can't remember which that students were told to underline the names of cases they mentioned in their problem answers, so as to make it easier for the examiners to mark their answers. The more cases they mentioned, the higher their mark. Of course, things are very different now, but it couldn't do any harm to underline the names of the cases you mentioned in your problem answer, just to make it clear how many you have actually mentioned. And talking of names of cases, sometimes you just won't be able to remember the name of a particular case that you want to refer to. That's absolutely fine. Simply mention some other feature of the case to identify it. So, for example, Feldhaus v. Bindley 1962 is a case which always seems to be sitting just beyond the reach of my memory when I want to refer to the case which helped to establish that you can't accept an offer of a contract through silence. But if the name of that case eludes you as much as it does me, it's perfectly fine to refer to it instead as the case where the uncle offered to buy his nephew's horse. 9. Advise the parties. Oftentimes a problem question will say, advise the parties, or advise X. Our first problem question, involving Henry, did precisely that. When a problem question tells you to advise X, it is not telling you that you should write in your answer, I would advise X that. What it means is that you should answer the question looking at it from X's point of view, that is, you should consider what claims, if any, X can bring, or what offenses X might have committed. It follows that a question that instructs, advise the parties, isn't saying anything. There is no particular angle or point of view from which you should approach the question, and you should simply answer it straightforwardly, adopting the approaches set out in this letter. Essays or problem answers. My students sometimes ask me, if we have a choice in the exam between doing an essay or a problem question, which should we go for? It's tricky. I think it's easier to write an essay that will get a high mark than a problem answer that will get a high mark. I'm talking here about discursive essays, which are the principal kind of essays you might get asked to write in an exam. The reason for this is that the general standard of essay writing among students is so low that an essay that is well written, interesting, and well argued will be seized on by the examiner with tears of gratitude and awarded with a very high mark. In contrast, to get a high mark for a problem answer, it's essential that you cover all the issues raised by the problem question, and don't make a mistake in discussing those issues. If you miss even one issue or misstate the law on one point, that will drag your mark down. So I often compare writing a problem answer with diffusing a bomb, one false step, and it's all over. And when I'm marking a problem answer that has started off well, I often find myself holding my breath. I'm in such suspense to know if the writer is going to be able to get to the end of the answer without it all going horribly wrong. In contrast, if you make one weak argument in an essay that is otherwise of a high standard, the examiner will usually be indulgent and think, well, so what if he or she made one weak argument? The overall standard was so good. This should definitely get a high mark. Given that, you might think my advice to my students would be to choose to do an essay over a problem answer every time. But there is a downside to that choice. It's this. Marking an essay involves a lot more judgment on the part of the examiner than marking a problem answer. So if you write an essay, you're always taking a bit of a chance with what mark you get for it. It may be that your essay is objectively really good, but it's given a poor mark because it rubbed the examiner up the wrong way, or because the examiner was in a bad mood when he or she marked it. In contrast, If you write a problem answer that covers all the issues raised by the question, does so in an intelligent way, doesn't misstate the law, backs up every legal statement by reference to a case or a statute, you can be sure you are going to get an excellent mark for your answer, whoever the examiner is. To sum up then, it's easier to guarantee a high mark for a problem answer than it is for an essay. You can never be sure that an essay you write will get a high mark. But on the other hand, it is easier to get a high mark for an essay than it is for a problem answer. So what should you do if you have a choice between writing an essay and a problem answer? If you are confident that you could write a better essay than a problem answer or vice versa, then obviously go for the essay or problem answer, as the case may be. If you are so talented that you think you could do both really well, go for the essay if you don't think there's much chance that what you say will rub anyone up the wrong way. You'll just have to take a chance on the examiner not being in a bad mood when he or she marks your essay. If, on the other hand, what you have to say is quite controversial and might annoy the examiner if he or she takes a different view, there's no point in taking a chance. Do the problem answer instead. All best wishes, Nick.